Can you please look up this site?
See if we can figure out something.
Good morning. Let me go for people.
Good morning, Assistant Public Defender Sandra White on behalf of.
Ms. Jones, if you could have them unmute you so you can state your name, please.
Oh.
Thank you. All right, we're here for a pretrial and bond violation in this matter. Ms. White, I received your mitigation statement this morning, and I just finished reading it. So where are we with this case, please?
Yes, Your Honor, we are asking the court if you would grant HIDA for Ms. Jones if she was to plead guilty.
What is your position on the HIDA request? Ms. McDuffie, please remind me. Your Honor, I wasn't opposed to it initially, but then Ms. Jones was violated with a new offense that she has pled to and is awaiting sentencing in 14A2. She failed to report for testing, so she had a bench warrant for that as well. And then there was a new thing, but that was a denied warrant. So I'm concerned, obviously, but I would also say that I have read the mitigation statement as well, and I can't understand how Ms. Jones is starting off on the wrong track, and her circumstances are not helping that. So I defer to the court in terms of granting HIDA. I'm concerned about how she's going to do, no matter what type of suit she has, quite frankly. Thank you. Well, here's the thing. The mitigation statement is obviously moving. Her actions are concerning. They almost cancel each other out. Because the reality is that given all that she's been through, my hope would be that she would choose a different path. And she is not doing that so far. So what I'm willing to do is give her HIDA, but that doesn't mean she's not going to get additional jail time until she figures this out. So HIDA does not negate jail time. So I will grant HIDA, but I'm not saying that I won't do more jail time. I'm willing to give her an opportunity to have a clean record in the end, but she needs to do better. And simple discussions is not changing her attitude or her behavior. So maybe some jail will. That is where I am, Ms. White. What would you like to do?
I guess I need to speak with Ms. Jones.
Okay. We're trying to break out with Ms. Jones.
Thank you.
All right, the court will recall the case of the State of Michigan versus Jones, case number 23S. Definitely for the people.
Assistant Public Defender Sandra White on behalf of us.
All right, what would your client like to do today, please?
We have discussed Your Honor's offer, and Ms. Jones wishes to accept that HIDA under those conditions, understanding that there will be jail time.
Sure. All right. So, ma'am, it's my understanding you will be pleading guilty to assault and battery. That is a misdemeanor carrying maximum penalty of 93 days and up to $500 fine plus court costs. The court has indicated that, which I am the court, that I would be willing to give you HIDA on this particular case, but with some upfront jail time, which you've already begun serving some of that time. Is that your understanding of the agreement?
Yeah, yes, ma'am.
Please raise your right hand, and is that what you want to do? Is that what you want to do, ma'am? Accept the plea?
Yeah.
The right hand, please. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? So help you God?
Yeah.
Is that a yes?
Yes.
Thank you. You may lower your hand. I'm going to go with my right. You have Ms. Jones that you're going to be giving up by entering into this plea. Please stop me if you have any questions, or if you feel like you want to speak to your attorney again, okay?
Okay.
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to speak, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself, or you can choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent, unless proven guilty beyond a reasonable doubt. Do you understand that?
Yes.
Do you understand you're going to be giving up all those rights and you're not going to be having a trial of any sort?
Yes.
Do you also understand that there's no automatic right to appeal this decision? So what that means for you, ma'am, is once you enter into this plea, in all likelihood, this is the plea that is going to stick with you. And the only way you can get this off your record is by successfully completing the HIDA program. Do you understand that?
Yes.
And do you also understand that if you were on probation, parole, or bond, when you committed this offense, you could be violated of that probation, parole, or bond? And this happened on September 24th, 2023. Were you on probation, parole, or bond on that particular date, ma'am?
No.
And then finally, if you're not a U.S. citizen, you can have immigration consequences. Are you a U.S. citizen?
Yes.
To the charge of assault and battery, how do you plead?
Guilty.
Has anyone promised you anything other than what we placed on the record here today to get you to plead guilty, Ms. Jones?
No.
Anyone threatening you in any way, shape, or form?
No.
All right. On or about September 24th, 2023, were you at the vicinity of our apartment number 2?
Yes.
And while you were there, was Karis there?
Yes.
That's your brother?
Hmm?
That's your brother?
That's my baby daddy's
Your
sister.
baby daddy, your baby daddy's sister.
Yes.
Oh. And did you assault or batter your baby daddy's sister?
Yes.
What happened?
We were into it, and well, she had hit me, and then she hit me and she ran in the room, so I ran in the room and I assaulted her.
So you ran behind her and then you hit her. What did you do?
Like,
You say you assaulted her. What did you do?
well, I hit her, like we were fighting.
So Miss White, it sounds like it was interesting. So she hit you and then she ran.
Yes.
How long before you chased her? Like, did you chase her immediately?
Like, I waited for my mama to look away, and then I ran in there for like a minute.
Oh, I see. Okay. All right. I find that there's a factual basis for the plea that's been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Ms. White?
Satisfied, Your Honor.
All right. So what's this other case that she has? Can you tell me about that, please? Ms. McDuffie?
Yes, her the newer 14A2 case is also an assault and battery against a different person that does not, I shouldn't say doesn't appear to be connected because the relationships could be, anything, but this is somebody who reported getting off the bus when they got sprayed with mace.
Oh, she sprayed someone with mace?
Yeah.
When did this happen?
On February 9th, 2024, when Ms. Jones was out on PR on this case.
All right, because I arraigned her for the, let's see, got arraigned by Magistrate Nelson in September, and then I got a bond violation report that I did nothing with. Then on October 26th, she failed to appear, and then she got a bench warrant for failing to appear. Then she came back before me, and I arraigned her on January 24th. No, she came before the magistrate. That's the magistrate's handwriting. Magistrate Braley this time. And then she appeared at the pretrial. Then that was February 5th. And so you said this happened on what day?
February 9th.
So in between the pretrial that she was here for and the next pretrial on March 4th, she sprayed someone with mace.
Your Honor, if I may,
And then you will in a second. I'll let you in a second. And then she came back on March 4th. That's when we modified the bond to allow her to have contact with Latara Jones. Is that?
That's her mother.
her mother.
Okay. All right. So now you may.
Ms. Jones admits that, as you know, this was her first offense, and she didn't understand the seriousness of everything. And she has been sitting for 30 days, and she understands, and she's had a lot of time to think and talk with me. She does want to start anew, and I have already told the court in my mitigation statement a lot about her. She wants to show herself and the court that she can make a change, and hopefully she can do it. And I understand that the court wants to give her more jail time, but hopefully not as much as less or more than.
Well, clearly she's violated the terms of her bond. She had a whole new case that she has pled to.
Correct.
She, after I modified her bond, something happened on March 6th. And she got a new bench warrant. Ms. Jones needs counseling. I mean, it's very easy to put in a report all these things and ideas that we sometimes superimpose on what people should be doing. I don't know whether this comes from you or comes from Ms. Jones, to be honest. What I do know is that her background is sufficient enough for me to want to give her some additional chance. So that's why I did it. But the whole hope for her brother and the hope for her, we as attorneys know how to word things so that it appears that our clients want what we think they should be doing. So I don't know if Ms. Jones gets it. That's what my concern is. Is she involved with CMH at all?
I don't believe so. Ms. Jones, are you with CMH?
And here I am.
Okay.
Your Honor, can we approach really briefly? I have a question.
Okay, we're back on the record in the Jones matter. Ms. Jones, it's my understanding that you may be able to go live at your uncle's.
Okay, I apologize.
It's okay. It's my understanding you may be able to go live at your uncle's.
Yeah, he wanted me to come stay with him when I got out of here so I could get myself together.
If he is willing to do a home confinement tether there, then I would consider that. There are some obligations and requests and orders that I have for you in the meantime. You need to have a signed contract with CMH before I will release you. So you need to be under their care. Now, once you get out, if you can find a different place for you to go and get some counseling, you can switch to that. But in the interim time period, you need to have a contract with CMH before you can be released. I'll release you to home confinement to your uncle once we get the address and the name of that individual.
You then need to look for a job and get signed up to get your GED and your diploma. And those things need to happen by the time you come back here for sentencing.
Okay.
Okay?
Okay.
Uh,
I have a question.
Yes, ma'am.
Okay, how would I give you guys the information on like the address and his name and stuff?
I'm gonna put you in a breakout room with your attorney as soon as I'm done. Okay?
Okay.
All right. So I'll see you back here on June 27th at 10 o'clock a.m. for sentencing. Okay?
Okay.
We won't be able to release you until we have that address and name, but once we have that, I'll give you an opportunity. Please see it as that, Ms. Jones. The behavior that you've been exhibiting, I know you think it's normal. You probably have seen a lot of it, but that's not acceptable behavior. And it's not all your fault. Some of this is learned. It's what you've been around. It's what you think is okay, but it's not. Do you understand that part now?
Yes, ma'am.
And I hope I don't want you to feel like I'm scolding you. I'm trying to get through to you. I want you to be the best version of you can be. And you got to get in a different environment to do that. Okay?
Okay.
All right now. I'm hoping and wishing you nothing but the best. And I hope that you believe that and believe that you can be better and do better so that everything that White wrote about what you want for you and what you want for your brother can come true. Okay?
Okay.
All right. I'll see you here on June 27th. Okay?
Okay. Thank you.
All right. Thank you. All right.
Jonathan Bolden. All right, are you all ready to proceed?
Yes, sir.
All right, we're going to go on the record. Court is calling 2022 CR 11444, State of Texas versus Jonathan Bolden. Can I have the parties announced for the record for the state?
Marjorie Hillno for the state.
Defense.
Brandon Lopez for Mr. Bolden.
And are you Jonathan Bolden?
Yes.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Jonathan Bolden who was placed on community supervision in 2022 CR 11444 for the offense of failure to comply with sender duty to register life or annual on April 3rd, 2023 for a term of 5 years? Is that you?
Yes.
State?
Your Honor, violated condition number 4. In Bexar County, Texas, the defendant, Jonathan Bolden, did then and there fail to report to the supervision officer as directed for the months of March 2024 in violation of condition number 4.
How do you plead to that? True or not true?
Your Honor, the state waives all remaining violations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 2 years in prison? Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. We are asking in court to grant the motion and revoke probation. We're asking for a sentence of 6 months in the Bexar County Jail. This is a second MTR. We understand there's some issues with completing the probation, so we're asking for the 6 months.
That is our understanding.
All right.
Okay.
So his minimum is 2 years. All right, let's go off a record for a moment. Allegations.
Failure to report.
I mean, probation is right here. So, I mean, we can do it now.
And I don't know, there's a new offense.
We can go on, what's the new offense?
It's a violation. I just don't know who submitted the offense report and everything. I have to do that. That one was gonna get to you guys.
All right, y'all want to just, I mean, LaShawn is here. Y'all want to talk to her and see if she can tell you whether or not he reported? Hey, it's not cold. Come on.
I think you're getting sick, Norma.
All right, so don't stand next to Norma. I think she's coming down with something. Okay. Oh, you guys are ready?
Yes, Your Honor.
All right, so what are we doing?
Your Honor, we were gonna maintain our plea of true,
Okay.
and you go open to the court as far as how to proceed forward.
Okay. All right, we're going to go back on the record and 2022 CR 11444, State of Texas versus Jonathan Bolden. Mr. Bolden, it's the court's understanding that you realize that the range of punishment is up to 2 years in the prison. Is that correct? Right. And are you still going to be pleading true to violation of condition number 4?
Well, I'm put it like this. I could honestly say, yeah, but in actuality, I did because I tried to.
I don't know. Here's the thing. With violations and motions, sometimes people will say, yes, I did not report. Hypothetically, I did not report yesterday. And maybe the reason why they didn't report is because they're in the hospital and they can't report. Technically and legally, you did not report. So you would be pleading true. And then you would say, but Judge, I have an explanation as for why I didn't report. So with regards to violation of condition number 4, are you still pleading true to that? All right. Do you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 2 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 4? All right. And state you're still waiving the other allegations?
Yes, Judge.
All right. The court will find violation of condition number 4 true. Is there an agreement?
I don't believe so, Judge. At this time, we're asking to revoke. We don't see that there's much else that can really be done if he were to be continued on probation. I believe defense counsel has asked for continued.
All right. So does anyone have any witnesses?
We don't, Your Honor.
All right. So I'll hear argument defense.
Your Honor, my client, as evidenced by his plea, did plead true, did miss reporting in March of 2024. On March 20, through discussions with my client and with probation, he missed his report date of March 26th. He called the office on March 28th to try to explain he's homeless. He lives on Ridman Road. Probation knows that he's homeless. He didn't have a bus pass. He made every effort to be there on March 28th. Did not make it by 5 p.m., but he did appear on April 1st, where a warrant had already been issued and he was arrested. He has every intent of complying with probation. Homelessness obviously being a big struggle, as well as many physical disabilities. He reports to me that he's been working to get full insurance to cover issues with his legs and his heart. If the court would recall, I think he was set 2 weeks ago. He was in the hospital for a stroke. So he has many health issues that he's been trying to get organized around. So he does understand that he missed it. He understands that those are his responsibilities solely, but he's asking the court for an opportunity to continue on probation despite this new issue.
So you're saying, let me just 1 moment. So he missed reporting on March, what date of March?
26th, it's a Tuesday, Your Honor.
Okay, so he missed reporting on March 26th. And then when did he report?
He reported the 1st, but in between that, Your Honor, he spoke with probation officer on March 28th, that Thursday. They informed him that he needed to be there by 5 p.m. He could not make it. He did make it that following Monday. And I believe a warrant had already been issued.
All right, probation.
Yes, Judge.
So did he call them and let them know that he's homeless?
There was a telephone call that was about the report on the 26th. There was a telephone call on the 28th. Didn't say anything about the officer or anything like that. The notes indicate that the officer told him to be at the location in person by 5 o'clock. Due to that, not reporting a couple of days prior.
All right, so Mr. Bolden, here's where we are. And maybe you can tell me something or your counsel can tell me something that will make me think differently. You're here on a failure to register. So that means that you are now on notice that you have to report and you have to register, right? You're supposed to report. Everyone here agrees, your attorney agrees, you agree, probation agrees, states agrees, that you're supposed to report on March 26, 2024, correct? Did you call probation on March 26, 2024? They don't have that.
I called him. I called my probation officer on the 26th. I had to, because let him know that I didn't make it in. He told me to contact, he said, contact the police.
let me do this. Can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Jonathan Bolton.
All right, and I'm assuming nobody's objecting to hearsay because I'm trying to get to the bottom of this story.
No objections.
All
Okay.
right, so what happened?
I called him on the 26th and said, I didn't make it in. I'm trying my best to make it in. I'll make it tomorrow. He said, you need to, because they want you to be there to register. I said, okay. So I called them. They said, you better make it in then. I tried my best to get money to get the bus to get out and make it. I could make it. So I called, but I called him back on Friday because the place was closed on Friday. So I called my probation officer back Friday and told him that he said I better make it. That's all I told him. That's all.
All right, so this is what I'm not understanding. You called them, you're telling me you called them on March 26th?
Yeah.
All right. And you told them you were not gonna make it.
I told him I'm trying to make it.
Okay.
And I told my
And you
probation.
didn't make it on the 26th. So then they reschedule you for March 28th to give you a chance to make it, and you still didn't make it.
No, they didn't reschedule me. I told them I called the 27th. I called the 27th because it was closed. I called the 27th and told the sergeant down there that I'm trying to make it. I don't have a way of it. I'm trying to get the money to catch the bus. He said, well, you better make it. That's when I called him back on the 28th and told him what that officer said. And I did all I could do. And then I sat in there early Monday morning to try to make it solve, fix it.
Well, see, here's the thing. And correct me if I'm wrong. I'm fine if you correct me. I don't take it as a sign of disrespect. You knew you were supposed to report on March 26th. You didn't report. You say you don't have bus fare. You can't get there. You didn't report on the 27th. And then they tell you you need to be there on the 28th by 5.
27th. That's when he told me, he said, you better get down here.
All right,
I
so-
couldn't do it. I didn't wait.
I don't know what I'm supposed to do with this because he was supposed to report. He didn't report. It's a lifetime registration.
Excuse me, Judge. Out of all the hard times I've had living in that field, moving in and out with medical things, they want me to move my stuff. Even when I'm medical hurt and I'm not able to. I mean, it's a big job. I'm right now coming out of that situation. I can be on, you can put me on no tolerance, period.
See, here's the thing. That's what everybody says when we get to this point for a motion to revoke. I have people who tell me, you can keep me on probation for life. You can do this or that. The problem is you haven't been reporting, and this is not your first motion to revoke.
Because I've been having trouble getting it before. I was on, when I got put on, I had to show there every week. I had no problems with the first 15 years. I had no problem because I had a job and I had got away. I have not had no source of income whatsoever. And I'm finding myself having problems. It's not that I don't want a problem. Register or go register. It's a problem I can't. I have trouble getting there. I'm not trying to display attitude that I don't want to do this stuff. I do want to be accountability for myself and for the things I do. It's just the money situation keep me from doing it. I'm not trying to blow it off. It's a no.
All right, just have a seat. I'll take this matter up in a moment. I need to think about some things. All right, Mr. Bolden. And we're not on the record yet, and then I'll take up the search warrant issue. So probation. What can we do with this? I mean, if it appears that from what the report I'm receiving for probation, it appears that he called in. It appears that he's homeless.
But I was just talking to both the state and council. I was just looking over the records from the last couple of months.
Could you mute us for a moment, please? So Hank and Daniel, you all are in trial?
No, ma'am, nothing yet.
Oh,
We're coming back tomorrow.
oh, did everything work out or no?
Most of the stuff has worked out.
Oh, wow.
One person is in the hospital.
Oh. Yeah. So who's the person in the hospital?
Local board
Ah,
for the drug cases.
okay,
Resolution on the regular states.
okay. Oh, could you stay for one moment? And is Zach upstairs? Is he available to come down? Oh, go up then.
So, I mean, I can yell, but I can stay for a second.
All right, sure.
Is it about tomorrow?
No. No, I'm sorry. Could you mute us again?
So we got, Fortis is up with, Marquise Jordan.
Okay. Yeah, no, that's good.
Thank you, Morning Judge.
Hey, good morning.
We just finished the first appearance. I mean, in jail.
No worries.
I can take over.
Yeah.
Changed it out. Getting triage this week. It's in the crisis.
Do you need? We're starting now first.
We're gonna start with number 2 because Mr. Fortis has an appointment he's got to go to.
Okay.
But if you want.
No, not, no, it's like. Oh, I guess.
I'm just doing it. Whoever.
That's what I was doing.
I see that email. What is that?
Tagged. Thank you.
So what in the hell am I supposed to? Huh? All right, I'm kind of curious.
Okay. See you around.
All right. All right, let's see. So this is position 2, 22 CP 209182, Marquise Jordan. Released May 22nd, 2022. He's got, let's see, 1, 2, 3, 4, 5, 6, 7, 8 counts of aggravated assault with a deadly weapon, 2 counts of criminal damage to property 2nd degree, 1 possession of a firearm or a knife during the commission of a felony, and 1 count of possession of a pistol or a firearm by a person under 18 years of age. Let me look at Marquise Jordan. So it's got him on inactive. Is his ankle monitor not working, Mr. Fortis? What's going on?
It wasn't working and he didn't know that. They called him on March 4th and he went in and they changed it out.
So is it working now?
It's working now. Also filed a motion to modify the bond as well because he's been going on almost about 2 years. I think it's in violation of the standing order. And I would ask that the ankle monitor requirement be removed.
Mr. Webb?
If that's true, Your Honor, there's no objection from the state.
Yeah, well, I mean, so there's, how long was it inactive, Mr. Fortis? Do you know?
Like 30 days or 45 days, maybe February,
So what made him know that it wasn't working?
they called.
He didn't know he wasn't charging it and it
It was
wasn't,
charging, it just wasn't working.
Wasn't putting up. All right, well, yeah, since, me and McBurney talked about it, well, so just get me an order to remove it. All right, Mr. Jordan, don't let me see you again, okay?
Don't see me again.
Judge, I'll get that over to you this afternoon.
Meaning, don't let me see you again unless it's on the street and you say, hey, how you doing, Judge? All right, yeah, just give me that order, yeah. Thank you. All right, let's see. I'm gonna call this counter if you could answer real quick if you're here, or let your lawyer answer. Jacobian Williams?
Morning, I'm here for Mr. Williams.
Judge, I'm having a hard time hearing.
Oh, okay, yeah, sorry. Is that better if she gets towards the podium?
Can you hear me now?
Yes, ma'am. Thank you.
Okay,
All right.
Hannah Rondon here for Mr. Williams.
All right, so it's 22 CP 207605. Got theft by taking felony, burglary in the first degree, possession of tools of a crime, entering auto with intent to commit a theft or a felony, and home invasion. Failure to charge is monitor who was released July 13th, 2022. Go ahead, Ms. Rhonda.
Your Honor, I believe we're here for a dead ankle monitor.
Uh-huh.
Yes, and Mr. Williams, if this is kind of the same announcement as the previous case, he wasn't aware of the issue with the hardware, but he has since gone to all county monitoring and gotten his monitor switched out. So I do believe he's got a working, properly charged ankle monitor as of today.
How long has he had his on?
Since about reporting to me August of 2022.
All right, Mr. Webb?
No objection, Your Honor.
All right, you want to get me something to remove it?
Yes, please, Judge.
Okay, we'll reinstate your bond. All right, sir. Stay out of trouble. Don't let me see you again, okay? All right. All right, let's see. Now we got Terrian Hudson.
Right, Your Honor.
All right, is Ms. Bumpus here?
Your Honor, Ms. Bumpus asked me to make an announcement on her behalf. She is running behind. She asked for you to hold for her report.
Okay, so have a seat, sir. We'll get to you in just a sec. All right, we got Tremaine Ward.
Hannah Rondon here for Mr. Ward. He's present.
All right. We've got 22 CP 214720 Tremaine Ward, 3 counts of aggravated assault, 1 count of possession of a firearm during the commission of a felony. Released 3/22/23, failure to charge the monitor. Go ahead, Ms. Rhonda.
And Your Honor, this is another situation where there was an issue with the hardware. Mr. Ward has gone and gotten the hardware switched out and it is now working and I believe actively charged as of this morning. Additionally, Mr. Ward's case, there is a motion to modify the conditions of his bond that was scheduled for yesterday, but Judge Brooks asked, or she informed me that the motion would be rescheduled for today so that we just have 1 court hearing and not 2.
Okay.
The motion for modification of bond is to remove the ankle monitor, as Mr. Ward has been on it since December of 2022, as well as to remove the 24-hour curfew condition, as to my knowledge, he's not had any violations of his curfew or any other conditions of bond other than the malfunctioning hardware since he's been out, which has been over a year.
No objection.
He's smiling, Ms. Rhonda. Am I ever going to see you again here? You promise?
I promise.
All right.
So he's doing well. I can
Yeah.
attest to that.
All right. All right, you can just send me that amended order.
All right, thank you, Judge.
All right, thank you. We'll reinstate it. Now we got Jaquan Mathis. Anybody know who took that case? That was Mr. Rose. Jaquan
Your Honor.
Who is that? Jaquan Mathis. All right, not here.
Your Honor, what was Mr. Mathis's case number?
It's 23 CP 215635.
Thank you, Your Honor. I'll look into it.
All right, let's see.
Your Honor, Ms. Saparazzi is signed that case and she just stepped outside to speak with another client.
Oh, okay,
We could just circle back to that one.
sure. All right, we got Donovan Wells.
Your Honor, that case was indicted to NC2.
So everybody I talked to yesterday told me just handle it.
I think you excused them, Your Honor.
Oh, this one's what, is this one I excused? It was Miss,
Ms. Collins' case.
Right.
gosh, Miss Beck, stop. Well, because it says Miss Gowdy. Look, Miss Beck, do not even be texting a message back there. All right. That's fine. So I got, all right, Miss Beck, you're on. Dwayne Stevenson. Where's Mr. Stevenson?
I am not sure, Your Honor. I would ask to hold, to see if he's just running late.
All right, we'll hold that one to the end of the calendar. About Tiffany Ingram. All right.
That's Miss Safarazzi's again. She's just right outside, but Miss
All right,
Ingram
so
is
I'll
here.
get you as soon as she gets back in, okay? What about Kendall McLaurin?
That's me, Your Honor. I'm not sure. I would just
Kendall.
ask to hold, Your Honor.
Okay. All right, we got Brandon Mack.
Yes, Your Honor, I do not believe Mr. Mack is here. We would ask just to hold to see if he approves.
Okay, we'll hold for that one. What about Arkezius Jordan? Let's,
Number.
We're gonna look that one up, Your Honor.
all right, let's see. Let's see. Oh, it's Mr. Sergeant.
He filed an entry 3 days ago.
Is he coming today?
I'm gonna reach out to him, Your Honor.
Okay,
We're checking, Your Honor.
all right. And,
Yeah.
all right, let's see. What about Tavarius Parker?
Attorney, yes, Your Honor, we would just ask to hold to see if Mr. Parker is here.
Okay. Saquon Bailey.
Your Honor, Mr. Bailey is outside speaking with Miss Sarfarazzi right now. That's who she's out interviewing at the moment, but he is present. I spoke to him. He's been present since like 9:15.
All right.
Oh, actually, that's
Okay.
him right there, Your Honor. They're present.
15 minutes.
We were doing calendar.
Oh,
She was
okay.
just asking about Mr. Bailey.
Yeah, I'm like, all right, and what about Amira Imani?
Walter for Amani. This is a case that was newly assigned to me, and so I would ask the court to reset so that I can find contact with her. I've already tried, and I would like to have some time to get my investigators to help find phone numbers and addresses.
What does the state say? Because I really don't have.
Is that position 15, Your Honor?
Yeah, there wasn't a, I know.
My calendar doesn't have a defendant's name on it, so
Amira Imani.
what were you requesting, Mr. Showalter?
That it would be reset for maybe 2 or 3 weeks for contact.
That's fine, Judge.
All right, we'll get you a date.
Thank you, Your Honor.
All right, we got Teresa Tillman. Looks like, hold on. What was it?
Attorney, yes, Your Honor, that case was actually dismissed.
Good
The
decline.
prosecutors filed a motion to dismiss, so I don't believe Ms. Tillman would be.
Okay. What about, let's see, Jordan Ford?
Yes, ma'am.
Let's see, Mr. Ford.
Attorney Consulting present, madam.
Okay, come on up. All right, this is 23 CP 220471, Jordan Ford, criminal damage to property in the second degree.
Yeah, what's it? Thanks.
Go ahead, Mr. Cazzoli.
Thank you, Your Honor. I don't know if we could hear from,
Same thing, I just got notes.
yes, Your Honor. So Mr. Ford is 36 years old. He lives in Jacksonville. And the reason he was here during the underlying incident was visiting, trying to find work. Your Honor, he has 3 children that are all in Florida. He was working at Cheesecake Factory upon release. And again, I don't know the exact details of when the ankle monitor company is saying he did or did not have proper monitoring. I know he was having some health issues associated with the ankle monitor, with his legs swelling due to his work at Cheesecake Factory. So, Your Honor, we are asking for a second chance here. Again, he made it all the way up from Jacksonville to be at this hearing, so we know he's somebody who will appear even when it's difficult. We are asking for a reinstatement.
Mr. Ford, did you call the ankle monitoring company to make sure it was working?
No, ma'am. Actually, when I got released, they gave me a paper with it with my book bag and stuff. I ended up throwing that old book bag away, being stuck here on the ankle monitor. But I ended up walking around, going to Sandy Springs where I don't even know nobody at. Ended up finding a job working. It just, when I plug it up, I don't know, it heat up on my ankle, it swell it up real bad. I went to the hospital for it, got some medication. It took a few months for it to heal, but I was still charging it. I just stopped charging it, and when I stopped charging it, it went down.
Probably need to, get him to call on Mr. Cazzoli.
Yes, Your Honor. I don't know if we have the number available. It's been a while since I took down that number.
Yeah, if we have it. We have it. Who's in?
So,
We have the number who we would need to call.
no, I can find out. Appreciate it.
All right, we can shoot it to you. So if you call and get it that replaced, okay? Because it shouldn't be heating up and burning your leg and things like that. What do you say, Mr. Webb?
That's fine, Judge. No objection
All right.
to,
All right, we'll reinstate, but make sure you call them or get, we can send you the number, Mr. Cazzoli, to get a new one.
Thank you, Your Honor.
Because you only got a little bit and it'll be,
a year.
yeah. All right. All right, best of luck to you, sir. About Robert McElhaney.
Your Honor, I'm sorry, and in terms of the ankle monitor, would there be a chance that he could get it removed at some point? Again, he did return from court from Jacksonville. Is there a chance we can get that removed either today or in the near future?
Oh, sure. Yeah, near future. How about that?
Okay, do you have a timeline? Because I think he was released in September, so it's almost 6 months already, or past 6 months already.
Well, if it's only been 6 months, we would request that he stays. It was put on in September, is that right?
That's my understanding. That based on the Odyssey, his release date is this month.
Okay. Well, I would say let's let it go at least 3 more months, Judge.
Let's give it a couple more months, Mr. Cazzoli. We'll get, he should be able, there should be some place down there since the new company owns them. They can go down there and get it taken off and mail it back.
Jacksonville, Your Honor?
Yeah, it should be,
Okay.
for sure. All right, Robert McElhaney.
Okay.
All right, so who's this one? Is it you, Miss Safarasi?
That's Ms. Brown.
Oh, okay. Oh, Miss Safarasi, you've got. Is it? Tiffany Ingram. I don't know if you've had a chance to talk.
Yes, Judge, I already spoke.
You've already talked with her?
Yeah, we're ready to go when you are.
All right, who's handling McElhaney? Robert
Yeah,
McElhaney. Okay, we'll do that and then we'll handle yours, man. All right, he's gonna get him.
Which, you're in the public defender's office?
Yes.
Nice to meet you. It's a name of a poet, it sounds like.
Judge, who's handling McElhaney? I didn't hear the name.
Well, we're gonna do position 18, Robert McElhaney. Did you get a calendar? We need to email you one.
I have a calendar. I just was trying to get the public defender's name.
My name's Barrett Browning. That's B-E-R-I-T. Last name Browning, B-R-O-W-N-I-N-G.
Thank you.
All right, this is position 1823 CP 221589. Robert McElhaney, M-C-E-L-H-A-N-E-Y. Obstruction, possession of Schedule 2 controlled substance, public drunk, and simple battery. It looks like he's been in for like 78 days on his new charge. Go ahead, Ms. Browning.
Your Honor, we are asking that Mr. McElhaney be given a signature bond. He is a lifelong Georgia resident, but he's currently homeless. He does collect disability and has for the last 7+ years due to some physical and age-related limitations. He cannot afford any type of good fund at this time, nor would he have access to his fund he receives from his disability. So at the time he cannot obtain EJR, then he will not be able to bond out.
What is his new charges?
I don't know. I was looking at Odyssey, Your Honor, and I can find, I saw an FTA that was after this, but it was closed.
Let's see. Let's see.
He did indicate that he had been detained in Covington.
Yeah, because the FTA was filed on February the 25th. Let's see. Well, on here it shows it's still open, but I don't know.
Maybe I pulled up the wrong FTA. The one that I had, it said closed on
Oh, I
it.
wonder if it was based on something on, because the 16 SC case?
Don't recall, Your Honor.
There's a 16 SC 143193. It was in judicial hold. There was a, think he failed to show up at a plea and arraignment. Let's see.
What was the date of that failure to appear?
The judicial hold was 1/12/2024. The plea and arraignment was 1/9. That's a criminal.
He was actually in custody in Covington at that time. Right after Christmas, he was taken into custody. So that was not a failure, a willful failure to appear. It was the opposite of willful. He was physically unable to appear.
It looks like he failed in October 13th, 2023 also, so there's a bench warrant. Anyway, so it's, that's a criminal damage to property in second degree, simple assault and obstruction. What, Mr. Webb, go ahead.
The state doesn't have any objection, Your Honor. I'm just looking to try to see what the new charge, it's in another jurisdiction. Is that what you said?
There was a bench warrant issued for a failure to appear at a plea and arraignment calendar
Oh, okay.
on the 2016 case.
Oh, okay. No, we don't object, Your Honor.
All right, so he didn't have any place, so are you gonna put him in touch with a?
Yes, Your Honor, I'm gonna see what we can do about finding a place for him to sleep. That is something that we can for him.
All right.
How long has he been on the ankle monitor, if I may ask?
Well, he was released 10/24/23,
Oh.
and he got arrested 78 days ago.
Okay.
But it is quite a hardship for him to have an ankle monitor because he does not have stable housing. Therefore, there's no reliable place for him to get it charged. And I do worry that that's just going to come up to bail.
All right, we can reinstate it, but Mr. McLean, you're gonna have to have some place to get court notices and all this other stuff because you're missing court and then they're issuing bitch warrants. This is gonna be a cycle. So I don't know if you have any relatives or a close friend that you can get an address, to get mail that can get in touch with you. And across the street there, they have phones, I think, once a month. Or they give out phones, so you have a cell phone. So there's some options out there. Maybe if you talk with your social worker, they can hook you up with some of that, okay? All right, we'll reinstate it.
Thank you, Your Honor.
Okay.
You're welcome, Ms. Browning. Good luck.
And Your Honor, that does conclude my business. May I be excused?
Yes, ma'am. Thank you. All right, now we got, let's do.
Your Honor, and I apologize. I have a quick announcement on position 11.
Okay.
I believe that was Mr. Jordan.
Uh-huh.
We were able to get in touch with Mr. Masajideen. He's actually on leave at the moment.
Uh-huh.
And it doesn't appear as though any coverage was gotten for this case. I'd be asking the court to reset this a week just to give me some time to get access to the file, try to contact the defendant and get them present. I don't want to punish them because they weren't notified simply because
All right.
we didn't have
We'll
contact.
send you a reset date. Thank you. All right, so, Ms. Ingram? All right, Ms. Safarasi, this is position 8, 23 CP 217248, Tiffany Gale Ingram, financial transaction card theft, entering auto with intent to commit a theft or a felony, and theft of mislaid property. Let's see, there's violation of stay away exclusion zone. Go ahead, Ms. Safarasi.
Yes, sir. So the stay away zone it's a place on Donnelly Parkway, 1332 Donnelly Holloway Parkway. It's right next to you said Bankhead?
Yeah, Bankhead train station.
It's right next to the Marta Bankhead's train station. So she thinks she maybe had walked past it to go to the Bankhead Marta train station, Judge. So it's not that she willfully was trying to violate or anything of that nature. She has to take the Marta. She's by the Bankhead station, so it was just an accident, Judge. So we're just asking to reinstate. She's been on the ankle monitor for 4 months, and I think that's the only violation. She's been keeping it charged. It's charged right now. She's in court today.
Mr. Webb?
Oh, thank you, Your Honor. I don't see a reason to revoke her based on that. I would have no objection to reinstating her bond.
All right, we'll reinstate it. Thank you, Ms. Ingram.
And Judge, I mean, to avoid this in the future, could we take away that stay away, or just so she can go, or can we add some permission to her to go to that train station?
That's fine with the state, Your Honor. I don't know the facts of the original, the reason for the original stay away.
Probably because I did it.
Just the incident, it's pretty standard with the instant location.
Yeah, it's pretty standard for me let me see, what.
Whatever the court thinks is appropriate is fine with the state judge.
Let me see something real quick. Is she still living on Holly Street?
No, oh, yes, I'm sorry.
Okay, hold on one sec.
Is the bail project going to stay on her bond?
My knowledge, they're not coming off the bond. We got the tornado down in those areas. No, no, it's Port Phillip. Did the bail cover about it? I missed it.
Bless you. What kind of locations? Is this an apartment complex or?
Apartment. It's an apartment. I think that's where the car was located. I remember correctly.
Is there a reason why she needs to use the Bankhead MARTA station on a regular basis?
I mean, I can go like to another train station. It's just when I was just walking past there or whatever. I mean, I can go to another train station.
How about we put, how can we modify it so she doesn't go into that complex?
Yeah.
The suffering.
That way she doesn't need to go in, just so she can take the MARTA and maybe more bottle.
Okay, so you just can't go into the complex, okay?
Okay, just don't go by. I got you.
Right, okay, all right, we'll reinstate it. Thank you, Ms. Ingram.
Stay away as much as you can.
Thank you.
Thank you. Thank you, Judge.
Okay, let's see.
State of Michigan versus Regina Brown, case number 24 FB 1088. Freaking with the people.
I'm sorry, I apologize. I misread it.
Okay, 1 second. Your attorney's not here yet, so give us 1 moment now, okay? Okay, thank you. State of Michigan versus Darius Prince, case number 23-00408. Freaking with the people.
Assistant Public Defender Allison Mueller, on behalf of Darius Prince. Mr. Prince, can you unmute and state your name, please? Mr. Prince, your video just went off. If you oh, there we go.
Yeah, I'm here.
Please state your name, sir.
Darius Prince.
Thank you. Right, in this particular matter, we are here for a pretrial today. The defendant was here on May 16th, where he was told at that time to continue his ETG testing and to return here, and we would be here for a pretrial and potential bond violation today. I got another updated violation report, but I do also have some documentation in here through May 16th for the ETG testing. So he's been testing at on-site.
Yes, Your Honor. Your Honor, do you see on the test results, mine go all the way up to May 28th?
I do not have that. I have through May 16th.
Okay, I can forward you what was sent from on-site to probation yesterday. I'm sorry, I'll forward that right now.
Thank you. And if somebody could share with me, please, I have nothing.
Oh, sorry, Ms. McDuffie, I'll send that now. This was last minute, it came through. On-site, it said they had faxed it last week, but I don't know if it didn't come through, so they emailed it directly to probation yesterday. I just sent it to everyone now.
It has not come through yet, in case you're wondering where we're at.
Oh no, I'm sorry.
Oh, you sent it only to Heather.
Oh, sorry, Judge, I can send it directly. Do you want me to send it directly to you as well? I'm sorry, I just am in the habit of.
Okay, we're printing it. Oh, I see. They sent it to the lab, and these are the lab results showing. We had a positive back on April 8th, and that's the only positive that we've had thus far. And he took the report. I'm sorry? 216 as well. He was arraigned on 214.
I see. Yes. Positive for alcohol. And he did not report for testing on May 20th or April 30th.
I've reported, I have not missed a date.
Well, all I'm telling you is what the report says, sir.
Your Honor, I have not missed a date. I did miss going in one afternoon because I had to work and I couldn't get off, but I followed up the next day.
Your Honor, I would, and I'm sorry, kind of in the busyness yesterday of we do know how we would like to resolve the case. So Mr. Prince and I discussed that, and we were trying to track down the results. I didn't speak with him about the results. If I could speak with him briefly in a breakout room about the positives and the missed test. Like I said, we do know how we're resolving the case. Mr. Prince will be pleading as charged to the offenses today.
I'll let you talk to him about what he wants to do with respect to the violations for the 2 positive ETG tests and any explanations regarding what they're saying on this test.
Okay, thank you.
Thank you. Recalling the matter of the state of Michigan versus Darius Prince, case number 23-00408. For the people.
Assistant Public Defender Allison Mueller here on behalf of Darius Prince. Mr. Prince, can you state your name again, please?
Yes, Darius Prince.
Thank you. What would your client like to do with respect to the bond violation?
Your Honor, he does admit to the violations of the 2 positives and the 2 missed tests. We would like to provide just context as far as the missed tests go.
Thank you. Mr. Prince, please raise your right hand to be sworn. I'm sorry, I don't see your right hand raised, sir. Mr. Prince, can you hear me? Do you swear or affirm that the testimony you're about to provide? You have a delay, that's what the problem is. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
You're breaking up. Breaking up, Your Honor.
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. Sir, you have a right to have a hearing regarding the bond violations. It's my understanding you're going to waive that right and you're going to admit to violating your bond by testing positive on 2 separate occasions, April 8th and February the 16th of 2024, and then also failing to report for ETG testing on April 30th and May 20th. Is that correct, sir?
Hello? Excuse me.
Did you hear me?
I can see you and hear you now.
This may not work out, Ms. Mueller. I'm gonna try one more time. If it doesn't work, then we're gonna have to do this on a different day where he may need to come into court.
Okay.
Okay. So, sir, can you hear me now?
Yes. Yes.
You're gonna admit to testing positive on April 8th and February 16th and failing to appear to test on April 30th and May 20th. Is that correct?
Correct.
All right. Thank you. I find that there's a knowing and willing admission to the violation. We'll take all the satisfactions at the same time. My understanding is he's also going to be entering into a plea today.
That's correct, Your Honor. Mr. Prince will be pleading as charged. I believe there's not an offer on this matter, and I did discuss with Mr. Prince about his license. It sounds like it'll take significant time for him to have a valid license, and so I advised him. I don't believe we'll be able to adjourn out as far as he needs to have a valid license.
Thank you. So, Mr. Prince, my understanding is you're going to be pleading guilty to operating while intoxicated, driving while license suspended, revoked, or denied, and having alcohol in open container in the motor vehicle. Is that correct?
Yes, it is.
Right.
But it wasn't in the front seat.
So one second. We're not quite there yet. I got to advise you of some rights before you get to that. This is a process. It's a fairly lengthy process, maybe lengthier because you can't hear me half the time. So, as to the operating while intoxicated, that is a misdemeanor carrying a maximum of 93 days and up to $500 fine and or 360 hours of community service. Do you understand that, sir?
Yes, I do.
Plus court costs. Count 2 is operating while license suspended, revoked, or denied. That is a misdemeanor carrying up to 93 days and or $500 fine plus court costs. Do you understand that?
Yes, I do.
And I'm sorry, this is the second or subsequent offense notice. Is that that's going to be applicable too, Ms. McDuffie? Yes, ma'am. All right. So that means that this carries up to 1 year and or $1,000 fine. Do you understand that part, sir?
Yes.
Okay. And then there's open alcohol container in a vehicle that carries up to 90 days and or $100 fine plus court costs. Understand all those penalties, sir?
Yes, I do.
All right. You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. And you have the right to be a witness for yourself, or you can choose to remain silent. If you choose to remain silent, the prosecutor cannot comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights, sir?
Yes, I do.
You understand you're going to be giving up each and every one of those rights, and you're not going to be having a trial of any sort.
Yes.
And if you were on probation, parole, or bond when this happened on January 5th of 2023, you could be in violation of your probation, parole, or bond. Were you on any of those on that date?
No.
And if you're not a U.S. citizen, you could have immigration consequences. Are you a U.S. citizen, sir?
Yes, I am.
On January 5th, 2023, well, first of all, to the charges of operating while intoxicated, operating with license suspended, second offense notice, and alcohol open container in a motor vehicle, how do you plead?
Guilty.
Does anyone promise you anything other than what we place on the record to get you to plead guilty?
No,
Has anyone threatened you in any way, shape, or form?
no, they have not.
All right, thank you. On January 5th, 2023, were you operating a motor vehicle at the vicinity of Rossville Road and Grove Road here in Ypsilanti Township, sir?
Yes, I was.
And while you were operating that motor vehicle, were you under the influence of alcohol?
Yes,
All right. And were your license suspended, revoked, and denied while you were driving?
they were suspended.
All right. And have they been, you've been convicted of driving while license suspended in the 45th District Court on or about October the 11th of 2013, and then in the 43rd District Court and on or about October 18th of 1995?
Those cases were not me. I know who did it. Somebody, I know who did it because I was living in Alabama at that time.
You were living in Alabama in 1995?
Yep,
In 2013?
2013. I was here, but I know who did both of those.
Well, did you do the one in the, let me see, I might have this backwards. So in 2015, you were in the 45th District Court. Or did you do that one?
What court was that? If I may ask.
I don't know. Ms. McDuffie, do you know?
I can help, Your Honor. So there's a 15, 2013, 95. I have the ROA in front of me for Oak Park. So that is a guilty plea by Mr. Prince, the driving with a suspended license that was entered on May 28th of 2015. That's in the 45th District Court.
Oak Park?
Oak Park, Michigan, yes.
Was that you, sir?
Yes.
Okay, I have enough. I need to go into the details about the other one. So, thank you. And then finally, sir, you were going to tell us you had an open container of alcohol in the front seat of the car, I think is what you said earlier. Is that correct?
No, it was up under the seat.
It was under the seat, but it was open?
Yes.
Okay. And what was it?
Brandy.
Oh, yeah, some brandy. Okay. All right. I find that there's a knowing and willing plea of guilty to all three of the charges as well as to the bond violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Ms. Miller?
I'm satisfied as well, Your Honor.
Well, one more thing I think I missed. Was there a BAC in this case?
I have a .131, Your Honor.
Thank you. Now I'm satisfied. Are you
Defendant
satisfied?
stipulates that and is
All right.
satisfied.
All right. Sentencing in these matters will be on July 11th, 2024 at 10 a.m. Sir, did you write down the phone number when I handed it out earlier for the probation department?
No, I didn't. I don't have a pen on me.
Well, you're going to need to call the probation department. So you might want to write this down unless Ms. Mueller can text you or something.
Yeah, Your Honor, I can text Mr. Prince. I can text you the number.
All right, because I'm at work.
All right, bond is continued.
Well,
So
Your Honor, I'm sorry, Your Honor, ask the bond because he did admit to the violations as well. I wanted to request, given that we have the positives, I'll save my commentary for when he's sentenced, but that Mr. Prince may need a sober link at this point rather than ETGs.
No.
Just a moment, Mr. Prince. Just a
Prince,
moment.
please don't interrupt. Anything else, Ms. McDuffie?
Well, yes, I guess I will say this one thing. When we were here on April 4th, I made a note to myself that Mr. Prince sounded like he was intoxicated on the record, and that I wanted to see his testing results. And then we've been going around trying to get those. So
All right, let's stop. We need you to stop.
Okay.
Intoxicated.
Hold on, please.
Satisfied as well, Your Honor. Well, it was literally right after Ms. Mueller said that she was satisfied, Your Honor, that it cut. So it was when you went to Ms. McDuffie to ask if she was satisfied and she started speaking.
Ask Ms. McDuffie first.
Okay, so then I'm sorry, I was fast forwarding it right here. So I did get Ms. Mueller
And
being
you
satisfied
got
as
the
well.
BAC.
I did not get the BAC. It was once Ms. Mueller. I mean, was it beforehand, Your Honor? Because I was speeding through to try and make sure that of what we got or not. I mean, if they
It
could
was
say
all in there.
if they can do the BAC, say the BAC again.
All right, we need to make sure that the BAC is on the record and they have stopped before then. My understanding is the BAC is 0.13, correct?
0.131, yes, Your Honor.
131, and you stipulated to that, Ms. Mueller,
I did, Your Honor.
and we are satisfied with the plea, correct?
Yes.
And you were making a motion, Ms. McDuffie, to add a sober link.
Yes, Your Honor. So given that Mr. Prince, we are also satisfied, I know the court wants to do them all together, satisfied with his admissions for the bond violations with the positive and missed results. My concern is that I made a note to myself on April 4th that Mr. Prince appeared, at least to me, to be intoxicated. He sounded like he was drunk to me when we were on the record on that date, and that I wanted to look at his test results. And it's taken us a lot of doing to try to get those. We finally got them today. And I'm almost not surprised to see the dates of those positive results on April 8th. He has a positive right after he was arraigned on this case and given his bond conditions, and then another positive result a few days after he appeared in court on this case as well. I think that given that, that it may be time for him to get on a testing method that will allow us more immediate access to those results, because I'm concerned that we have positives at all, obviously, and that they've taken place after he's been seen by this court, days after he's been seen by this court twice now.
Thank you. Ms. Mueller, a couple of things. One, you needed to provide me with an explanation as to why he missed several tests, and then two, you can respond to Ms.
McDuffie's request.
Thank you, Your Honor. So for the April 30th, he did miss that. He works in maintenance. He sometimes works late. That night he was on call. I believe on-site closes at 7:30. He worked after that. When he reminded me, he did let me know of that situation. So I can at least verify that that's the reason he provided me at the time. It's the same reason he provided me now. Same reason on May 20th, where he missed. I did want to just show that he did go the next morning at 5:37, I believe, right on the 21st. So he missed on the 20th due to work reasons, but came very, very early the next morning to make up that test. So he did miss. The one time he did try to make it up as soon as possible. I understand the concerns. I do. It has been since April 8th, the last positive. So that does show, at least since that day, a good track record, at least of negatives since then. And for that reason, just for the recent weeks of testing and all negatives, I would ask the court at this time to leave the testing in place. It seems like Mr. Prince has found his rhythm with on-site. He can't miss anymore. And he knows that he's got to get to on-site. He can't miss because of work. And he's aware of that. So at this time, I would ask the court to leave testing as it is. And of course, if there's more violations, I understand that the situation would change. But at this time, I'd ask the court to leave it in place.
Thank you. All right, Ms. McDuffie, I hear you and I heard your request. At this point, I'm going to leave the bond conditions where they are, Mr. Prince.
Thank you.
Mr. Prince, if you have another missed test of any sort, if we don't get these results in a timely fashion, if you have a positive test, you're going on to the server link at a minimum, if not jail time. You understand?
Yep.
Okay. And I'm doing that because the last result was back on April 8th, and we're almost a month and a half out from that. I'll see you back here on July 11th, sir. You need to contact probation tomorrow after 9:00 a.m. and schedule a time to have your pre-sentence investigation report done, which includes having an alcohol assessment. If you miss that appointment or anything else, then you will be going on server link. Okay?
Yep. Thank you, Your Honor. Thank everyone. Everyone have a good afternoon.
Thank you, sir.
You too, Mr. Prince.
David, Michigan versus.
Hello, Your Honor.
Good afternoon.
How are you?
I'm very well. Are you here on behalf of BTD Holdings?
I am.
All right. All right, you're in the right place. Our small claims cases are set to start in about 4 minutes. We're trying to get all the parties lined up right now. We have at least one person here live, and we have some others that are in various states of getting logged in. Mr. Kemp, can you hear me?
Yes, can you hear me?
Yes, I can. Where are you?
I'm at I'm in the truck at the work site.
I'm not able to hear. I'm sorry. I
No, I'm not
apologize.
either.
Can you hear me?
No, where are you? Where are you presently located?
Let me turn my volume up.
Where are you?
Can you hear me now?
Yes.
Hear me?
All right. Where are you?
I'm sitting in the truck in Centerville.
All right. Where is your truck?
Can you hear me?
Oh, we can't even get to first base. What I want you to do is drive to the
It's here by the courthouse.
Yes, I want you to come to the courthouse. Mr. Kemp, can you hear me?
Okay.
Come into the courthouse.
Yeah, can you hear me?
Yes.
All is lost. We're all doomed.
I want you to come into the courthouse. There's no way we're going to be able to do this with this connection. So, do you understand?
There may be a way, Your Honor, to dial in. I'm on my phone only because I have an Apple computer and I'm not able to use this. I called the court today, actually.
Yes.
And I'm only able to do it on a Windows computer.
Well, I've done it on my Apple iPad quite often.
I think you can do that. Yeah.
Stop. Mr. Kemp, can you hear me? I think he's in the parking lot, is my point. All he needs to do is come into the building.
Hello.
Hello.
Good afternoon. Are you Mark Ludeman?
I'm Matt Ludeman, that is correct.
Matt Ludeman. Which case are you here on, Mr. Ludeman?
With Superior Fence and Rail and Cassandra Burton.
All right, very good.
That's a different case, Your Honor. I'm actually on Connor Advertising.
Yes, I understand, Mr. Chilwich.
Oh.
I've got 5 cases going at the same time.
I'm sorry.
And I'm
Okay,
trying
I
to orchestrate
apologize.
all the cases.
Okay,
You're
I
just one of
apologize.
several cases that's set.
Very good.
And so I'm struggling with Mr. Kemp, and
Okay.
I'll get to you in due
No
time
problem.
here.
I've sat in court many times as a litigator.
Mr. Ludeman?
Yes, sir.
I'm going to ask you if you take your hat off. We are in a court proceeding.
Oh, I apologize.
Mr. Kemp, can you hear me? Hello, Deputy Tyler. I'm looking for a gentleman who I believe is out in the parking lot. Joe Kemp, and he's got a very bad connection. He's in a truck with his window down. No, I can't get head nor tail out of the guy. I think he's Amish. Joe Kemp. All right, thanks. Welcome to Small Claims. Mr. Kemp is, for all practical purposes, not present. But he's out there in cyberspace somewhere. All right, I'm not sure which one of these cases is the most or least complicated. I haven't had a small claims case in several weeks, and the clerk thought it would be a good idea to set 5 cases at the same time. We now have Mr. Kemp in the conference room, so that's helpful. Mr. Kemp, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, this is much better. We'll get to you here in a moment. All right, let's start with our Connor Advertising versus BTD Holdings. Let me get to this case. Everything is electronic. This is a claim for $7,000. Unpaid invoices for billboard advertising. Somebody told me that you couldn't get any billboard advertising because the dispensaries had taken up all the billboards. But let's see what we've got here. We've got Mark Pratt for Connor Advertising. Mr. Pratt, what's your position there?
So I am president of Connor Advertising. It's a single member LLC.
All right. And we've got Daniel Chilowich, BTD Holdings. What's your position there?
Yes, Your Honor. I'm a member of the LLC.
Will you both please raise your right hand? You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
All right, Mr. Pratt, you sued for $7,000, which is the maximum under small claims at the current time. You're claiming that you have at least $7,000 of unpaid bills for billboard advertising. Is that correct?
Yes, sir. I attached copies of the unpaid invoices as well as photographs and descriptions of the billboards involved. Let's see, the program ended. I canceled the program due to non-payment about a year ago, and I've been trying to work out. There's never any dispute as to the delivery of service.
Well, let's find out. Okay. Mr. Chilwich, what's your position here?
On the matter, my position,
yes.
First of all, let me say this. Mr. Pratt and I have, I think, always had a very civil relationship. I had one question. I just got these documents from my manager of my store. I actually live in Florida, so I'm not there. I just had one question, and then I'll be able to answer that if it's okay to ask. I don't know when the billboards were taken down. I just wanted to, I couldn't find the information, and there's a reason I'm asking, but otherwise, this is a very straightforward matter.
When were the billboards taken down?
That was June 30th, 2023. And I believe one of the contracts had, we didn't renew.
Right.
And that was, so one of the billboards ended at the end of April. And then one ended at the end of June.
Okay.
And
That
was canceled due to non-payment.
okay.
And I would agree, Dan. We've had a good relationship, and I, was hesitant to bring this to court.
I know.
We weren't able to work out any type of
Yeah,
payment.
and I regret it's nice to meet you first of all in person, and I regret that we're meeting under these circumstances. Your Honor, I don't dispute that this money is due. I can say that our business had a very difficult time. We're trying to get it back on its feet. We had a couple of issues. One of our partners had to be removed from the company, and we then went through a robbery, and it just became very, very difficult. What I had thought, and again, I just got these papers, I'd like to try and propose something. There was a time that we were trying to pay $1,000 a month. It's just not possible. So what I was gonna, and that's what happened. It just became very difficult. What I'd like to propose is either a settlement and compromise payable in 7 days, or a payment plan that I can suggest if Mr. Pratt is willing to, consider that. I do want to get it all paid.
I would probably set the payment plan at $500 per month.
Okay, what I was going to suggest, if we can do it, was $333.33 a month for 12 months with a balloon payment of, I'm sorry, I think it was a balloon payment, $333.33 times 12. With a balloon payment in the 12th month of the $333.33 plus the balance of $4,000. So the whole amount, or I was going to suggest a settlement and compromise of $4,000 in full now within 7 days. And I'd leave that to Mr. Pratt if it, pleases the court.
Mr. Pratt, he's proposing a lump sum settlement of $4,000 within 7 days. If that's acceptable, I will record that. If it's not, he's proposing $333 per month for 12 months with a $4,000 balloon payment at the end of 12 months. That would be acceptable to the court. Which of those options would you prefer?
Can I counter, Your Honor?
Sure.
I would counter with a $6,000 settlement. The original amount was $7,800, so I'd already given up on the $800. So if Dan, if you're able to pay $6,000, we could be all done with it.
Okay, let's do that, Mark. Again, it's always been our intention to make the payment in full. It's not something, again, but I can do that, and let's try to resolve it and shake hands and
all
move
right,
on.
I will show $6,000.
Okay.
$83.50 in cost. Due within 7 days.
Yeah, well, I'll try to take care of it tomorrow, Mark.
7 days from today would be June 10th.
Can I just ask one question? Mark, do I have all of your information? Is it the same? I'm fairly certain we have it on our wire instructions. It's not going to be coming from BTD, since BTD has no money in the bank. It'll come from another company, which I've always sent to you from that same one. But I just want to make sure I have the right information. Or if not, if I can contact you and get it, I'll check as soon as we get off this call.
All right.
I'll wire the money.
I can put you in a breakout room and you can share that information to make sure you got
Okay,
it.
that's fine. If that's okay with you, Mark, that's fine.
All right. right, I'll put you both in a breakout room. When you're done, you can just go. Did he already go?
Sorry.
I think he left already.
Oh, okay.
I was gonna put him in a breakout room with you, but he's not.
I
on
can,
my
I
screen.
can, I can send him an email. I mean, we have a very
All
good
right.
relationship, so
All right.
it's not a problem.
All right, very good.
Thank you, Your Honor. Have a lovely day.
Thank you. Miss Griffith Matthews, can you hear me?
Yes, can you hear me?
And Mr. Tyler, you can hear me. I'm gonna take this off me so they can see you. Would you both please raise your right hand? You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do. Yes.
All right. And Ms. Matthews, what's your position with Mendon Schools?
I'm the superintendent.
Superintendent in Mendon covers a lot of different job descriptions.
Yes, it does.
But let's talk about this. This is a situation where the school provided training funds to train Mr. Tyler as a bus driver under the condition that he remained for a certain period of time. I'll read the summons and complaint. Mr. Tyler entered into a contract with Mendon Schools in July of 22. This contract stated that Mr. Tyler would receive the training to be a bus driver with the obligation of 2 years of employment with the school. The training was to be deemed repaid at $500 per semester. Mr. Tyler resigned from his position August 31st of 23, therefore owing the district 2 semesters $1,000. Ms. Griffith Matthews, that's your position?
Yes, it is.
Mr. Tyler's here with me in the courthouse, and he was here early and ready to go. Mr. Tyler, what's your position?
My position is that I think the issue is they need to rewrite the way they do their contract, because this was me turning my keys in for the summer. This, if you see the so-called resignation letter, I made myself available for them. And I went on and I reached out to the principal and to the bus director and told them that I would be available for sporting events. If they needed to call me, they needed to give me a call. They never called me, and they took this as a resignation. And the contract does not say, Your
Well,
Honor,
do I have what you're referring to? Well, do I have that?
It's a handwritten note from him with his keys. We don't turn our keys in for the summer. So, yeah, this was on August 1st. It's a handwritten as part of the packet, I believe.
Let me scroll down, man, and scroll
Okay.
down far enough. Here's the contract dated 7/29 of 22. Then he was informed in August, this is to inform you that the Mendon Community Schools have acted on your resignation at their regularly scheduled meeting. Please accept this letter as written notice that you no longer work for Mendon Community Schools. No, I guess I didn't go here. Here are my keys. I care about the kids in our school more than anything else. Have the school call me when they are ready to have someone that can drive for them for the next 20 years, driving bus and not a van. Right now, it definitely seems like something that can't be done. Sincerely, Robert Moses Taylor. P.S. I would hope the school would not try and sue me because it's just not worth it to them. Well, guess what? Apparently it is.
yes, it is. It is.
And what the fact that, and it doesn't say that in that letter, that you may be available for sporting events and other special transportation isn't the same as having a daily bus driver. And the fact that you turned in your keys certainly would indicate that you were done. Where does it say you were willing to work part-time?
Those were sent in emails to the principal.
Well, you owe him $1,000. You signed a contract and you breached the contract. Are you driving a bus now?
I'm driving a bus that doesn't require CDL.
Okay. All right. All right. Can you pay that within 21 days or do you need some sort of payment plan?
I definitely need a payment plan, sir.
All right.
I'm one of the lower income families in Mendon, as it is.
All right. Can you pay $100 per month?
I would agree to that.
All right. I'm going to find $1,000 for the plaintiff. $63.65 filing fee, and the service fee is $55.54. The total is $1,119. At $100 per month, that will take about 12 months. We're going to start this July 1st. All right, it just sort of is what it is. I do respect the fact that you respect the process. You were here live, ready to state your position, but contract is a contract. That's why it's there. All right, you owe $100 per month for the next 11 months and then $19.19 for the 12th month. All right, I'll have the court officer take you out. You can get a copy of this judgment. You make the payment directly to Mendon Community Schools.
Okay.
All right, thank you. Good luck, Mr. Tyler.
Thank you.
Thank you.
Your Honor.
Yes.
Don't forget, I'm going to tell that lady about the job.
Well, we still,
Everybody.
just give me your first name.
Sarah.
All right. Yeah, she's in the pile.
Okay, thank you.
Okay. All right, Miss Griffin, Matthews, you're good to go.
Excuse me, Your Honor.
Yes.
Yeah,
Mr. Connor, I lost you.
Apologize.
I was
apologize.
gonna put you in a breakout room and you were gone, so you're free to go. He was gonna email you.
Very good. Okay, all right.
Mr.
Thank
Pratt.
you very much, sir.
All right.
Appreciate your help. All right.
Okay. What have you got? Yes.
I have an iPhone that just attached and it just says iPhone. Who are you? You're muted.
Oh, I don't think that's me. Can you hear me, Judge Mogen?
I can hear you, Miss Shannon. It's not you. It's a different iPhone.
Okay.
And it's not
just
Mr.
making
Gramstrup.
sure.
It's another individual. Who else just came in?
Dylan Hasbrook.
All right. We will go on the record in the matter 23 CF 212, State of Wisconsin versus Dylan Hasbrook. The state appears through District Attorney James Renicky in person. Mr. Hasbrook appears by telephone. We have Defense Counsel Christopher Gramstrup by video conferencing capability or video conferencing. We're set today in this matter for status conference. Mr. Gramstrup, please update the court.
Your Honor, I kind of hate to ask for more time on this matter, but I really do need some more time. Dylan's trying to, and he's worked diligently at it. He just doesn't have them. There's some records that I have asked him to obtain that I think could impact negotiations in a positive way for him. Part of the difficulty is one of the facilities has closed down and he's trying to track down the records keeper of that facility. So that's where we're at.
All right. Well, I will give you one more status, but then that's it. We're going to set it for a jury trial if it doesn't resolve. Okay.
Understood.
Can you do June 19th at 1:30?
Yes.
All right. June 19th at 1:30. We will see you then. We will go on the record in the matter 24 CF 72, State of Wisconsin versus Stacy Shannon. The state appears through District Attorney James Renicky in person. Ms. Shannon appears by telephone. We have Christopher Gramstrup by video conferencing. We're set here today in this matter for a status conference. Mr. Gramstrup, I have reviewed your motion to withdraw, as well as the proposed order indicating that there has been a breakdown of communication between you and Ms. Shannon, and that she has asked for a different attorney. Is there anything else you would like to add to that?
No, I don't think so.
All right. Ms. Shannon, I'm sure that your attorney went over the fact that you can't just ask, you can ask the court, but you can't just get it if you ask to have an attorney removed from your case. I have to go
Actually, I
over and
wasn't
get-
made aware of that.
Okay, well,
kind of part
it's
of
my
the
choice.
problem here.
Stop talking, please.
Yeah, I
It's my
understand.
choice. It's my choice. It's my decision and what I need to do. Therefore, and I have to go over certain factors. But with regards to this matter, I will approve it. It's been your first request. This is not a very old case, so it's going to go to the public defender's office. And hopefully you'll get a new attorney here soon. What I'm going to do is I'm going to set the matter for, I'm going to set it for June 24th at 11:30, June 24th at 11:30. And then hopefully you'll be able to get another attorney and we'll be good to go. Okay.
Okay. Thank you so much.
Thank you. We are adjourned. Mr. Zappa. We will go on the record in the matter 24 CF 70, State of Wisconsin versus Carl Zappa. The state appears through District Attorney James Renicky, Mr. Zappa in person, Mr. Gramstrup by video. Mr. Gramstrup, update the court.
Your Honor, the matter is not resolved and Mr. Zappa is requesting that the matter be set for a jury trial.
Well, one more time, I'm going to give you one more time to be able to figure that out and see if you can get it to work and get it resolved. Main Street, East and Webster,
Yes.
7325.
Yep.
Do you have a PO box or anything? We're getting mail returned.
No, my parents actually have a mailbox at that address, so yeah, it's 7325 Main Street East, Webster, Wisconsin, 54893. I had other mail get delivered there. I don't know why some's getting rejected, but they do have a mailbox.
All right, so we'll try and confirm that. 11:45 on June 13th, 11:45, June 13th, we'll have a last status. If we don't reach an agreement, we will set it for a trial, okay?
Very well.
Thank you. We are adjourned.
All right. The 14th District Court of the County of Washington, State of Michigan is now in session on the business for the court drawn here. The Honorable J. Cedric Simpson presides.
You may be seated. Court does call the case. Jeff Lewis and Julie Lewis versus Jennifer Loud.
Good morning, Your Honor. Daryl Barton appearing on behalf of the Lewises.
All right.
We're both present in the court today.
Yes. And Ms. Loudon is not present, and I'd informed or sent a message down to the courtroom that I wouldn't call this until 10 o'clock, giving her time to get here. My staff did remind me that at the last hearing, I believe on May 28th, she was also not here, and we adjourned it because she said that she thought it was at 11 instead of 9. We adjourned it out so that everybody wasn't held. There was a confirmation from her when we gave her the new time of the 9 o'clock. She confirmed that it was 9 o'clock and she is not here. The only thing I did not check, can we just run down to courtroom C and just make sure she's not here? I should have done that on my way out. I apologize.
That's all right. We'll wait.
Did Miss Barton say wait? In all the years, that's probably the first time ever.
What did
You're usually I said you'll wait. And I'm thinking that's got to be the first time ever that you have said that to me. It's like her case doesn't get called first. She's like all over me.
Last time you're gonna check my ID too. At least you're not telling me I'm not who I am.
That's true.
Yeah.
I don't. I don't have a counterclaim file. I don't see a counterclaim.
Understanding is that everything the removal has been received and should be.
I do see that. No, all right. Had my, so the record's clear. I had the bailiff, Mr. Allen, go check to make sure that she was not down in courtroom C. She has failed to appear. Would you like to take a default on this case?
Yes, Your Honor.
All right. Do you solemnly swear from testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Go ahead.
According to the information provided by my client, the amount outstanding that was originally asked for was $9,200 plus cost plus the statutory interest that has accrued since the original judgment.
All right. The 92 plus cost. The defendant or the defendant having failed to appear, judgment will enter.
We will go on the record in the matters 23 CT 92, 23 TR 949, State of Wisconsin versus John Dolney. The state appears through District Attorney James Reneke in person. Mr. Dolney appears in person without counsel. We're set here today in this matter for a status conference. Mr. Dolney, where are you in the process of getting your license?
I got the confirmation number through the IID program. I'm just waiting to get I got to figure out if I'm going to go to Cumberland or to Spooner to get it set up.
You are so close then, right?
Yeah. Yeah.
So close. Why don't I push this out? Hopefully you'll have this done by July 11th. I'll schedule you for July 11th at 9 o'clock. If you get all of that done and you get everything installed and you're able to get your license, bring your license to him. Yes. And then you won't have to come back. Okay.
Sounds great.
So hopefully you can get it all taken care of by July 11th.
In the amount prayed for of $9,200 plus could the cost, applicable cost and attorney fees and interest.
Did the case number change now that it's general civil, Your Honor?
I think the only thing that happens is a GC is added. Is that just a G?
Okay.
Okay. Just a G will be added to that.
And we'll prepare a judgment for that amount
and I will sign it upon its presentation to the court.
Okay, I have another question, and that is, we also, come on. We'd also plan to submit a request in order to seize property with the judgment involved, if that, and ask that you sign it also when it's submitted.
I believe with the default, I have to wait the 21-day period.
That's right. So after the 21.
After the 21 days when that's submitted, then
I don't want to have to come back.
Any post-judgment remedies you can submit, then the court will sign off. And
thank you. That's funny. And just to be clarified, they have a security deposit, which they've not touched through this whole thing. They want to be able to immediately use it.
Let's do it this way. How much was the security?
It was $1,100.
1,100. Was any of the 9,200 rent or utilities?
Yes. 3,200 was the water bill.
Okay.
About $3,000 in rent.
Okay. Then under the Security Deposit Act, they could use that to cover for rent and utilities. So
landlord
it's not for damages. Just make sure that it's
for utilities
separated in that fashion. Yes.
I love it. Landlord Tenant Relationships Act.
Yes. All right.
Thank you, Your Honor.
Thank you. Yes, ma'am.
We enjoyed seeing you on the national news.
I can't tell you the number of people who told me that one.
You and a lot of other people, and I guess I will thank you for that. All right. Thank you. Take care.
You have whatever kind of day